This video on the Modification of Child Support process in Maricopa County is presented by the Law Library Resource Center, which is part of the Superior Court of Arizona in Maricopa County. Links to forms, packets, and other resources are available in the video description below. This flowchart shows the basic steps of the process we're reviewing today. We're not going to discuss it here, but it is included with the documents made available at registration. You may find it helpful to refer to during the webinar. Our forms are grouped into packets and steps. Each major step is a packet of forms, instructions, and procedures. You generally need every form in a packet. Depending on your circumstances, there are some packets, like the Step 2 service packet, where you might not need every form. Here you can see that there's 3 different processes to modify child support and one that also modifies spousal maintenance. In this workshop, we're going to cover several things. First, we'll look at the packets to modify support, which include 3 options. You can modify by agreement, which is when all parties agree and sign the forms together. This requires the notarized signature of both parties. We'll also go over the simplified process, as well as the 2 standard processes. One standard process is for modifying child support along with spousal maintenance. The other is for modifying child support only. We'll also cover the forms involved with these packets, as well as the child support worksheet and ezCourtForms. And finally, we'll go over the process once you've completed the necessary forms. Which forms you can use will depend on a few things. First, was your support order issued by the Superior Court in Maricopa County? If not, has it been registered here, and do you have a Maricopa County case number? If you don't, you'll need to register your order before you can modify at our court. Read the checklist for forms to register a foreign order, which is on our website, to be sure you qualify to register your order here. And if the state is involved in your child support order, only they can ask to move it. Next, is the current order for parenting time still current, or does it need to be changed? The child support worksheet you provide to the court has to be based on the current court-ordered parenting time schedule. If your parenting plan needs to be changed, you'll need to look at the forms that go over how to modify parenting time and child support. Do the parties agree on all of the changes? If the parties agree and will both sign forms in front of a notary or court clerk, this is the easiest process. And finally, will you be asking to order the amount that's on the child support worksheet? If you use the simplified process, you can only ask for the child support guideline amount. This is the amount on the child support worksheet calculator. You can ask for something different, even 0. This is called a deviation, but you'll have to use another process to ask to deviate. If your current child support order is not from Arizona, generally you must file forms to modify in that other state. But there are a few exceptions. If the other party still lives in the original state, you can file to register your child support order here, but only to enforce it. And you can only modify the order here if the other party agrees. If both parents have moved out of that state, you can file to register your order in the state where the children currently live. If you file to register your order in Arizona, you'll have to wait until the Arizona court accepts the registration before you can file to modify support. If the other state is involved in your child support case, only that state can move it to Arizona. You'll need to contact that state agency to ask them about the process. You may have reasons for choosing one process over the other, and there are also some limitations on when you can use certain processes. The simplified process can only be used if the child support guideline amount shown on the worksheet is at least a 15% change from the current child support order. Also, you can only ask for the amount on the child support worksheet. You can't ask to deviate or ask for a different amount. Finally, after the other party is served, they'll have to file to object and request a hearing. But if there is no objection, the judge will review your request and may grant your change without a hearing. For the standard process, you must describe a substantial and continuing change in circumstances on your petition. Examples might include a change in job, a change in income, a new child from another relationship, or a child under the order has reached age 18 and is no longer in high school, but you still have a minor child on the order. Also, both parties must complete an Affidavit of Financial Information form and attach pay stubs and tax returns. Finally, once you file your forms, you'll immediately get a hearing date. And there are other things to consider. Has the child support obligation ended for all minor children? If the youngest child is 18 but still in high school or a GED program, the order continues until they graduate or turn 19. The obligation ends when the youngest child is 19 or older, or the youngest child is 18 and graduated from high school or received a GED, and there are no arrears owed. If all support obligations have ended and the support is withheld from the payer's paycheck, see our forms on how to stop an income withholding order. If all support obligations have ended and support is paid directly to the other parent or to the clearinghouse, see our form called Notice of Termination of Child Support Obligation when there is no income withholding order. If support is still owed, but you want to change the amount, you would need to modify the child support. When a change is granted, the court will modify the income withholding order. Okay. Here's some important information on filling out court forms. When printing and saving court forms, all documents must be one-sided. This is because they're scanned and saved electronically, and anything on the back will not be scanned or filed with the court. All of our forms are fillable PDF files, and they can be typed. While they don't require it, judges prefer typed forms, and it's highly recommended that you type your responses. But if you do handwrite them, your writing must be printed and legible, no cursive writing. Also, you can only use black ink. And one more thing, do not leave blanks. If something doesn't apply to your situation, just cross it out, write NA for not applicable or put unknown. When you file your papers, a filing fee is due. If this is the first time you are filing papers with the court, meaning you did not file a response or answer in the original case, then you will also have to pay a first appearance fee. That fee is the cost of the original response or answer fee. Always check the Clerk of Superior Court's website for current fees. Also, you can submit a fee deferral application to ask to waive or defer the fee. A waiver means the fees will not be owed at all, but this is only available in limited situations where you have no earned income and may be receiving certain types of government assistance. Deferral means you will owe the fee later. You may have to pay part of it now and part of it at the end, or you may be able to pay all of it at the end. You might also receive a payment plan. Most people qualify for some kind of plan. If your fee is deferred, there will be a one-time charge of approximately $35 added on. You can apply for a fee deferral or waiver in person or online. It's recommended that you complete the child support worksheet first. This will let you know what the guideline amount is and help you decide which process to use. You must submit the worksheet when you file the Simplified Process and when you submit forms by agreement. The worksheet and order forms are not in your packet. Use the ezCourtForms program, which is available through our website. If you are submitting forms by agreement, both parties must sign the form in front of a notary or court clerk. If the Arizona Division of Child Support Services is involved in your case, they must also sign the agreement form, and they must agree to the change. If they don't, you won't be able to use the agreement process. When using the standard process, both parties must complete an Affidavit of Financial Information form, also called an AFI. The AFI requires you to attach your last 3 paycheck stubs and the last 3 years of your tax returns. It's a confidential document and not available to the public or most court staff. There are 2 of these forms in the packet. you must provide a blank AFI to be served on the other party. ezCourtForms is our online child support calculator. You'll have to create an account to use it. The account allows you to create and save multiple versions of the worksheet. You can go back to make changes and play around with the numbers at any time. You can access ezCourtForms at the link and QR code on your screen. The Arizona Child Support Guidelines formula considers several things. First, it considers the income of both parents. If you don't know the income of the other parent, you can use an amount you know they have made in the past or are capable of making. It would then be their responsibility to dispute that amount. If needed, you can use minimum wage at 40 hours per week. The formula also considers the parenting time arrangement, whether either party has children from other relationships, any extraordinary medical expenses of a child, and more. For the agreement and standard process, you can ask to deviate from the guideline amount. Deviation means an amount different than the guideline amount, even when the deviation amount is $0. The court has to approve a request to deviate. They must consider the best interest of the child when ordering a deviation. ezCourtForms will prepare 3 forms. These include the worksheet showing the amount of guideline child support, an order based on your choices in the interview, including deviation, and a current employee information sheet which is used to start, modify, and stop an income withholding order. You'll need to print these forms when you're ready to submit them. Now we'll discuss some other forms you'll have to complete. These forms are in the packets on our website. You'll always need to complete the case caption, which takes up the top third of the first page of each form. This is where you'll put the information of the person who's filing. You must include your name, address, and your phone number. If you've asked to have your address protected by the court, you can leave it blank. Make sure to include your email address here if you want to be contacted that way. And if you're representing yourself without a lawyer, you must check this first box. The case caption also includes the party designations. Enter the name of the petitioner, or Party A, and the name of the respondent, or Party B. These designations will never change. If you're the petitioner, you'll always be the petitioner, even if the other party later files to modify the orders. Also, be sure to enter your case number and your atlas number if you know it. On the agreement and standard petition, you must complete this section in its entirety. There are similar fields on the specified petition. Order issued on means the date of the current order you wish to change. Order issued by means the name of the court. If it's our court, write Superior Court. For located in this county, if it's our court, write Maricopa. And total current is the total from the amounts you list below. On this line, you'll enter the amount of current child support and spousal maintenance. You'll also need to enter the clearinghouse fee, which is $8. And here, you need to put any court-ordered arrears. Generally, these are considered monthly amounts. If so, enter per month. The last paragraph is asking about your current court order. Find the page and paragraph that details the order you're trying to change. The paragraph is usually numbered or lettered. If you don't know or aren't sure, then attach the relevant pages of your current order. And don't forget, you must complete all of the sections and questions on the form. On the Simplified Petition, you also complete the case caption. This petition has similar information regarding your current order under questions number 1 and number 7. And again, you must complete all sections and questions on the form. You'll also need to complete question 5 to show that the difference is at least 15%. Make sure you follow the directions. Here's an example. A is the current order minus the proposed new guideline amount on the worksheet, B is the current order amount. And C is A divided by B. To get a percentage, multiply the answer by 100. In this example, the current order is $200 and the proposed new amount is $250. Subtract the current order of $200 from the new amount of $250. This gives you $50 for A. Next, enter the current amount into B. In this example, B is $200. To get C, divide 50 by 200, which gives you 0.25. Multiply 0.25 by 100 to get the percentage, which in this case is 25%. As we said before, the Affidavit of Financial Information, or AFI, is a confidential document, and the information you enter is not accessible by the public. It's required when using the standard process. A copy including all attachments must be served on the other party along with the other forms. The document gives the judge the big picture version of your income and expenses. That's why it asks for the income of others who live in your household. Their income cannot be used to pay your child support, but it does show where your expenses might be lower and could explain why your household can or can't afford certain expenses. You must attach your last 3 paycheck stubs and the last 3 years of your tax returns. You must also fill out every question. If something doesn't apply, write NA for not applicable. If you're estimating an amount, write estimate or EST next to it. And unless it says otherwise, amounts should be listed as per month. Now we'll look at the agreement process. First, complete the forms and make sure both parties sign. The forms must be signed in front of a notary or in front of a court clerk when you file. You also need to complete the agreement, the child support worksheet, child support order, and the notice of lodging. Next, you'll need to make copies. You'll need the original and 3 copies of the agreement signed by all parties, the child support worksheet, and the child support order also signed by all parties. You'll also need the original and at least 1 copy of the notice of lodging, and you can make more copies if you or the other party wants them. If the support is withheld from a paycheck, you'll also need to complete the current employer information sheet. You'll need it in order to change the income withholding order. You'll only need 1 copy of this form. And if it applies to your case, you'll also need an order stopping income withholding order. And if the Division of Child Support Services is involved in your case, you'll need to get their signature on the agreement and child support order and provide them with a copy. You'll need to attach the following to the original notice of lodging: the child support worksheet, the child support order, and if applicable, the order stopping income withholding order. When you file the notice of lodging, the clerk will keep the original with attachments and return the filed endorsed copy with no attachments. You'll need this copy for the next step. Filing the notice of lodging means the judge will have to take action within 21 days. They can grant or deny the orders or set a hearing. You'll need to prepare 2 or 3 large envelopes with postage. 1 will be addressed to you and 1 will be addressed to the other party. If DCSS is involved, you'll need to make a 3rd envelope addressed to them. The next step is to deliver the forms to the clerk of Superior Court. You'll need to bring the original notice of lodging with attachments, a copy of the notice of lodging, and the original and all copies of the agreement. While you're at the clerk of court, you'll either pay the filing fee or turn in a completed fee deferral application. The clerk will file the notice of lodging and agreement and return file endorsed copies to you. Then you must deliver the following: a file endorsed copy of the notice of lodging and the agreement, originals and copies of the child support worksheet and the child support order. If applicable, originals of the current employee information sheet, and also, if applicable, the originals and copies of the order to stop an income withholding order. You'll then wait for the judge to sign the order and return the copies to you using the envelopes you provided. If the judge sees any issues, they'll set a hearing. Now we'll go over the simplified process. First, you'll complete the petition to modify. Then use ezCourtForms to complete the Child Support Worksheet, Child Support Order, and the Current Employer Information Sheet. For the simplified process, you'll need the original and 2 copies of the petition, the Child Support Worksheet, and the Child Support Order, along with 1 additional copy of the proposed order for the other party. If applicable, you'll also need 1 Current Employer Information Sheet, which is for changing the income withholding order. And if DCSS is involved, you'll also need a set of copies for them. Then, prepare 2 stamp envelopes addressed to you and the other party. Deliver all sets of the petition and child support worksheet, 3 copies of the child support order, and the envelopes to the clerk of Superior Court. While you're at the clerk of court, you'll either pay the filing fee or turn in a completed fee deferral application. The clerk will keep the originals and return conformed copies of the petition and child support worksheet to you. Once that's done, you'll need to arrange to serve the petition, child support worksheet, and proposed child support order on the other party. And if applicable, you'll also need to arrange to serve DCSS. We'll go over how to serve someone in a little bit. When other party has been served, file the proof of service with the clerk of Superior Court. Once the proof of service is filed, the judge will wait 20 to 30 days to see if the other party files an objection. If no objection is filed, you'll wait for the judge to sign the order and return copies to you. If an objection is filed, the judge will set a hearing and mail a notice to you. Next, we'll take a look at the standard process. First, complete the forms. You must complete the petition and the Affidavit of Financial Information. For the standard process, you'll need the original form, plus 2 copies of your Affidavit of Financial Information with all attachments, and 3 copies of the petition. That extra copy is for family administration. And again, if DCSS is involved, you'll need another set of copies of everything for them. Once everything is prepared, deliver all sets of the petition and AFI to the clerk of Superior Court. While there, pay the filing fee or turn in a completed fee deferral application. The clerk will keep the originals and return conformed copies to you. Next, deliver 1 conformed copy of the petition to Family Administration. They'll set a hearing and give you an order to appear with dates for a conference and a hearing. You'll also have a conference with court staff immediately before the hearing. Once all of that's done, you'll arrange to serve the other party with the petition, your AFI with attachments, a copy of the order to appear, and a blank AFI. They must be served at least 20 days before the conference or hearing. And if applicable, send a copy of the petition, your AFI, and a copy of the order to appear to DCSS. Then, file the proof of service on the other party and DCSS if applicable with the clerk of Superior Court. Finally, prepare for the conference and hearing. Bring copies of what you filed and any supporting documentation in case there's a challenge. So, once you've filed your forms, the next step is to arrange to have them served on the other party. Information and forms for this part are in our Step 2 service packet. There are a few different ways to properly serve the other party. The acceptance of service method is generally the cheapest, and if you work well together, this might be the best option. You'll need to either mail or hand to the other party a copy of the papers as well as the acceptance of service form. They must sign the acceptance form in front of a notary or court clerk. Then you need to make sure that the form is filed with the court. Service is not considered effective until the acceptance form is filed. We recommend you fill out the form, except for the signature, to be sure all the needed boxes are checked. Signature confirmation is the next cheapest method. You can use the United States Postal Service or National Delivery Service like UPS or FedEx, but it must be sent with restricted delivery and with signature confirmation. This means you need to get the signature card back so you can attach it to a form that gets filed with the court. You must take the signature card and file it with the form called Affidavit of Service by Signature Confirmation. If neither of these options will work or the other party refuses to sign, you'll have to hire a process server. Private process servers must be registered with the state. You can do an online search or go to the ezCourts.gov website for a list. The Maricopa County Sheriff's Office can also provide service. They have civil service offices at the downtown and North Phoenix court buildings. If the other party needs to be served in another state, the process server must comply with that state's laws. The process server should return an original or filed affidavit or a declaration of service form, but it's important to note that if they give you the original, you must go to the court and file it. Service is considered effective on the date the documents are served to the other party. Now, if the other party lives in another country, service is a little more complicated. In this case, you'll have to serve them under international law. There are special rules for international service. Each country has their own process, and many countries are party to an international treaty. You can find some more information about this on the U.S. State Department's website. The link and QR code to that site are on your screen. Because serving someone in another country can get very complicated, we recommend that you talk to an attorney for help. If DCSS is involved in a child support case, you'll also have to serve a copy on the Attorney General. They have a drop box, the clerk will tell you where, and they'll sign an acceptance of service form. When you go there, you'll need to provide them with the form and a self-addressed stamped envelope so they can send you your copy. The Attorney General may then file the form with the court and mail you your copy. But if they return the original acceptance to you, you'll have to file it with the court. Also, you must make reasonable efforts to locate and serve the other party. This includes doing things like mailing to their last known address, calling them, contacting family, friends, or employers, reaching out on social media, emailing, and texting. If you try and still can't locate the other party, you can file a motion with the court asking for approval to use an alternative form of service. The forms and instructions for this are in our Step 2 service packet. But remember, you must wait for a judge to grant or deny your motion for alternative service before you can try it. If a hearing is set, you'll receive an order to appear. Read it. It will tell you how to prepare for the online hearing. The judge may have special instructions. Also, you might want to organize and bring your expense and income records in case they are challenged. And be sure to join your hearing on time. Before we wrap up, here are a couple of tips and reminders. Whatever packet or form you're working with, be sure to read it all the way through before filling it out. All the instructions, steps, and procedures, including the links, phone numbers, and locations we've discussed today, are included in the packets. And if you haven't done so, you can use the address or code you see here to download the forms we've discussed.
Finally, here are some resources that the Law Library Resource Center offers. The Law Library is open Monday through Friday from 8 a.m. to 5 p.m. We're available in person, by phone, by email, and by live chat on our website. The Law Library also offers several services to help you with court forms and court navigation. You can attend an online webinar that features a live question and answer session at the end. Topics include divorce, modification of child support, sealing of criminal records, and more. Appointments for a 15-minute forms review are available. You can ask questions about your court forms or have them reviewed for blanks and missing information. However, to use the service, you must have completed your forms to the best of your ability. The Family Forms Clinic brings Arizona Legal Center attorneys and ASU law students to the Law Library to help you fill out family court forms. And a Lawyers in the Library program offers free 15-minute appointments for legal advice. This service is only available in person, with same-day in-person sign-up. If you're interested in any of these services or events, please visit the Law Library Resource Center events calendar for dates, times, and scheduling information. And while the Law Library can't offer legal advice, there are many free and low-cost options available. Community Legal Services is the local legal aid. You have to qualify based on income, and they only handle family matters when domestic violence is involved. The free legal answers site is only available online. You submit your questions and an attorney will respond. You have to qualify based on your income, however. The Family Lawyers Assistance Project is volunteer attorneys offering free 30-minute appointments by phone to those who qualify based on income. You can use the library's Unbundled Limited Attorney Services list to hire attorneys for piecemeal work. You pay only for the services you need. The Maricopa County Lawyer Referral Service refers you to an attorney for a $50 half-hour appointment. And the State Bar of Arizona Member Services site is a directory of all the attorneys in the state. Please check the description below for links and other resources.